I now see he's joined the meeting fully. This matter comes before the court at this time on a motion to modify temporary order filed by Mr. Hawley on behalf of his client back on January the 7th. I will note that I did receive a concise exhibit list from Mr. Hawley explaining his apparent position regarding the issues raised, a temporary grant of spousal maintenance, and a child support order being issued in this case. I want to just check with you, Mr. Hawley, on some details of your worksheet.
Yes, Your Honor.
Number one, it would appear that on page 1 of your worksheet, you're contemplating a temporary spousal support order of $753 a month. Is that correct?
Yes, sir.
All right. Furthermore, I think your worksheet contemplates a direct expense sharing plan between the parties.
No, Your Honor. At the top of the page, these new worksheets, I hate these new worksheets. The old ones were much easier to read. These new worksheets, you can't really tell whether you're doing shared expenses or mom pays expenses or dad pays expenses. But the worksheet that I've submitted to the court is mom pays expenses. And I tried to denote that up at the top of the child support worksheet.
I see the little teeny tiny print.
Yeah, I guess we could try to make that bigger. I'm going to talk to Bradley about that. But yeah, it's unfortunate. You can't really tell from the worksheet itself whether it's directed, whether it's mom pays expenses or shared expenses. But in this case, we are requesting mom pays expenses.
All right. All right. With those clarifications made, Ms. Chrisman, what's wrong with Mr. Hawley's computations here?
Certainly, Judge. So we do actually think that mom's income is too low. When I run just based on her income, we come up with $3,894 with my client at $7,271. We do note that mom is underemployed. My exhibit 8 shows that mom is working an average of 64 hours biweekly, which is underemployment. There's no reason for her to not be full-time employed. When we run it through the Bradley calculation, we do get $675. We would argue that spousal maintenance isn't justified under the case law, but it certainly wouldn't be over $700. We would propose that it be $500 if the court finds that it is justified. However, when I think that you apply the factors of in re hair, I don't believe that it is. Some of mom's statements in her domestic relations affidavit are incorrect. There are 3 different debts that she's assigned to herself that we're certain she is not paying or they're not monthly, such as the loan to Bob Cox, which is her father, and then also the home association debt. That would be a one-time payment. We're not aware that it's actually been paid, and so that's not a monthly amount. That brings her negative down to 124 rather than the negative 689 that she's stating. My client did submit a first amended domestic relations affidavit. He is in the hole as well, about $1,700. He doesn't have the ability to pay spousal maintenance. He is requesting that he cover direct expenses. He does acknowledge he has more income than her, but a differential in income is not the only justification of spousal maintenance. Dad also provides the difference between covering the children and himself. He covers $144 of health and dental each month for the 3 children. And so that's not included in Mr. Hawley's worksheet either. Obviously, there would be no temporary enforcement fee, anything like that. And then again, my client's asking that he be the one that covers direct expenses because he does have the higher income.
All right. I trusted that Mr. Hawley had simply added up what appears to be year-end W-2 information on the mother, added those, and then divided it by 12. That's what his mother's income calculation would seem to reflect, a relatively simple computation. And so what's wrong with his computation, Ms. Chrisman? Why is that incorrect?
Certainly, Judge. When I look at the subpoenaed income information that I received, I haven't gotten a W-2 from mom. But when I look at
Mr. Hawley's submission to the court,
And as I said to the court when I asked for the continuance, I was in trial yesterday. I didn't have the proper time to prepare for this. But when I look at mom's income from the subpoena, she was working from July 28 to December 14, 20 weeks, a gross income of 17,974.32 divided by 20 weeks. This is all in my exhibit 13 on page 49. It
Which I
gets her,
don't have, counsel. I'll just point out. I don't know how you think those got to me.
I provided them to your administrative aid.
When?
Guys, this case opens quietly, but the tension is already baked in. Support numbers, worksheets, and money questions start stacking up fast, setting the stage for a serious fight.
11
I've been in
a.m.
hearings, so
Okay.
I haven't seen them.
Which was the reason why I asked for the continuance in the first place. I got less than 24 hours and I was in trial and to look at David Hawley's. So I am also submitting exhibits, but I'm trying to walk through the calculations because the court wants to move forward.
I do. So go ahead.
Okay. So if you break that down by 20 weeks and multiply it out by the 52 weeks, you get a salary of 46,733 divided by 12 months, 3,894.44. Again, she's underemployed, but that is what the calculation is based on the subpoenaed results that I received.
Your response to that, Mr. Hawley?
Well, first of all, Your Honor, I would say we've got a 13-year marriage, so quite a long-term marriage here. Certainly would support a temporary order of spousal maintenance, which we're requesting. There's 3 children born of this marriage. The original filing granted the parties shared custody, but said that there should be no child support whatsoever paid to either party. And there was, as I pointed out in the email to the court, there was no child support worksheet filed with the initial filing back in September. And we did subpoena Mr. Sanders' income. And actually, we have the same exact amount of income on our worksheet that they have on their worksheet. With regards to her domestic relations affidavit and the income, I believe the child support guidelines say that you should use 12 months of income. And we have attached her W-2s from 2024 based on the 2 jobs that she had. I would like to address just briefly on her domestic relations affidavit. It does show that she is $689 to the negative. I will tell the court that this loan that's owed to Bob Cox, it's actually her father. They purchased some vehicles, and her father basically loaned them the money to purchase it, and they were paying them back. We gave Mr. Sanders credit on our domestic relations affidavit for $225 that he wasn't paying. He hasn't been paying his half of that Bob Cox debt, so my client's been paying the whole entire thing. And she has been paying the lows. In fact, the lows now she's paid off. So she's actually upside down $914, which we think more than substantiates our request for the $753 in spousal maintenance. With regards to his domestic relations affidavit, I would ask the court to look at his original filing. When he originally filed his domestic relations affidavit with the initial papers, it showed that he had $1,915 left over. So he could easily pay that. I would also say to the court that my clients become aware, Mr. Sanders is a police officer with the Wichita Police Department. My client is a counselor. We believe that he may have some extra income working as a security guard, as many police officers do, and that's not reported on his domestic relations affidavit. And we'd like to definitely, we need to include that into his income. I don't even know how much it is. We can certainly attempt to find that out through discovery later, but we believe just based on his year-to-date earnings and her 2024 earnings that our child support is correct. I would additionally say that even though this was filed as shared custody, since the parties have separated, my client is a therapist and actually works 3rd shift uniquely. So she does remote therapy from home at night while the children are sleeping. Mr. Sanders has to be to work very early in the morning. And so he was bringing the children to my client's house at 6 in the morning. And then she would take him to school at 8 a.m. because she was available. And then she would sleep. Then Tuesday through Thursday, she would pick them up at 3:15 and have them until 5:45 when Mr. Sanders would come home. He works Tuesday through Friday, I believe, 4 10s. And he's off on Monday, so that's why she doesn't watch him on Monday. But then on Friday, the kids, they go to Augusta schools. They, for some reason, they let out at 1:30 on Friday. So she's been watching the kids from 1:30 to 5:45 on Friday. That's 21 hours every other week. So the parties do week to week shared custody, and on his weeks, she was watching the kids for 21 hours. She still wants to call it shared custody and is willing to do that, but I just think that is an extra fact in her favor. Unfortunately, I think it was last week, he stopped allowing her to watch the children, just sent her a text message and said, you don't need to be watching the kids anymore. So we don't know what he's doing. That just very recently happened. But with regards to her, Ms. Chrisman's statement that she's underemployed, I mean, she's making $42,000 a year. And also, too, she's watching the kids 21 hours a week every other week. So she'd like to continue seeing the kids. I don't know what he's doing for daycare during that time period, but I mean, the kids ought to be with the mom instead of with some daycare. And again, she just got a text message saying, hey, I'm not bringing them over there anymore. So that's all she knows. But we believe that pursuant to the guidelines, you should use 12 months of income. That's what we've attempted to do on our worksheet. We've got the same number that they have. There was no expense sharing plan filed with the case either. There was some language in the temporary order in Ms. Chrisman's defense that did lay out how the shared expenses were to go. But as Your Honor knows, if you don't have an agreed shared expense plan, then one of them has to pay expenses, and usually that's the person who makes the lesser amount of money. I can tell you that my
Let me
lawyer
stop you
told
there.
me.
Wasn't there a shared expense plan set forth in the temporary order?
Yeah, that's what I said. There was some language in there about shared expenses. You're exactly right, Judge. That's why I corrected my statement. She did have some language in there about how they were going to share the expenses. You are correct about that. But there was no child support worksheet. And even under a shared expense plan, my client would still get child support. Even if there was no spousal maintenance, due to the disparity in income, he makes double what she makes. I mean, my client would still receive child support even on a shared expense plan, and they have no worksheet that's even attached. So,
Let me ask a practical question here, Mr. Hawley. Should your client prevail, at least on the child support issue currently before the court, and have some sort of subsidy, can she, on her income, afford to pay the direct expenses on these children?
Yes. She is now, Judge. She's only received $860 since the filing of this case from the father. I mean, she's basically paying for all the expenses now. And certainly with the spousal maintenance that she deserves, we believe that she can easily pay the expenses.
All right. Ms. Chrisman?
Thank you, Judge. I would like to point out it's not in my defense, Mr. Hawley. I didn't file the case, and so I have the unfortunate task of having to overcome the fact that some of these things were not complied with, and I agree. There is no agreed shared expense plan. There is terms in the temporary order, and there was no child support worksheet. I agree that would have been appropriate. This is something I'm trying to clean up and get everything square. I think that it's interesting to say that your client deserves.
Allegations fly about safety and violations, sounding serious enough to change everything. Then the judge asks one simple thing, show me where it's written, and the story starts falling apart.
Spousal maintenance, that's not the law. There's need, there's ability. Your client doesn't have the need. She hasn't been able to demonstrate that she has the need. At this point in time, my client I would point out that in my client's first domestic relations affidavit, he had not purchased a home and he did have $1,950 left over. Since that time, he's taken on a mortgage on a new home that is almost $1,500. That is listed in my first amended domestic relations affidavit, which I submitted with my exhibits. I think it's still making its way through e-filing. I have no knowledge of any type of supplemental income. I will definitely inquire about that and let you know. As far as the week on, week off, there are a few concerns that have led to a change of how the parents were doing some things. First off, the respondent mother has started having a boyfriend around the children in violation of the temporary orders. He's at the house a lot. We think maybe he's contributing to the financial expenses. Also, mom is working third shift during her parenting time. We're not sure if she has the children when she is sleeping. There are some safety concerns there. My client has enlisted the help of another law enforcement officer, which is her name is Melissa. She's a sergeant. He has incurred childcare expenses, but in fairness to mom, I did not include those in our proposed child support worksheet because he made that choice. I think in a final a final child support worksheet, I think that would need to be considered. But right now, everything is in flux. They are doing a week on, week off. He's not relying on mother for any type of transportation during his week. At this point, I just don't think that she can say that she deserves spousal maintenance, considering all of the factors. My client, and you've even said in email, my client has provided more than $800 to her. There are multiple Cash Apps, multiple Venmos, things of that nature. So he is providing support as well as having children half of the time and incurring childcare expenses. He does have more income, and so he will be able to pay direct expenses. I think that that's more appropriate. But these parties, they do have equal parenting time.
Where does it say in the original temporary order that they weren't to have someone else around the children? Would you point that clause out to me?
Certainly, it'll take me a second just to pull that up.
Please do.
If it was my order, I would know right where. Judge, it's possible that Ms. Schodorf, Trevor, I know that you're muted right now. You had pointed this out, so do you know if it's in there?
I remember reading it, but
Okay.
I don't know exactly where it would be at.
And just for the record, Judge, I would say my client denies that she's had anybody certainly spending the night or around the children a lot. So, I mean, she denies that allegation. But I don't see it in the temporary order either.
Sure, Judge, and it's possible that I misspoke, just based on what my client had said. I'm not finding it and doing a search, and I don't want to waste the court's time.
All right. I didn't find it in there either. So, all right. Counsel, this case has been open for 6 months now. We need to work toward a final resolution of the issues as well as temporary ones. How much more discovery or how much more time will be necessary to get this case ready to try or to get the case settled?
Judge, I have
Molly?
sent, oh, I apologize.
No,
Sorry.
go ahead, Ms. Chrisman.
I've sent an informal request for some more documentation. I think that will round out. I have settlement documents that are ready to go, but there is a little bit more financial information from mom that we have requested, specifically about this loan from her father and what exactly the expectations are, things of that nature. There's just a few more things that we've requested. Mr. Hawley just indicated he maybe is going to do another subpoena or something of that nature, but I would hope that we're very close. If not, we certainly need to get these parties into some kind of mediation or dispute resolution or something.
Judge, if I could respond, I've worked with Ms. Chrisman before. I have no doubt that we'll be able to share, that we're not going to have to issue formal discovery to get what we need. We did send a proposed debt and asset sheet to them, I think last week or a couple weeks ago. And so we have been actively exploring a full settlement too. But I would imagine if Your Honor wants to set maybe like a pretrial date in 30 days, I think that would be plenty, and we ought to be a lot closer to see where we're at. But we are asking for these for the modification of the temporary order to relate back to October 1st, which would be the first month after the filing. But I think if we set a pretrial in 30 days, we should be everybody's position should be known, if not completely settled.
Would not the more appropriate date for modification be the first month after you filed your motion? I mean, a long time went by and Michelle did not contest the provisions of the temporary order.
Yeah, we weren't really aware of his income. We had to issue a subpoena to the to his job to get his income. There was no child support worksheet attached. I guess we could have went off the domestic relations affidavit that was filed, but again, we believe it's underreported as income. And in fact, I'm looking at his DRA right now, and he put down that he made $6,600 a month. And I think we both now agree that he's actually making $7,200 a month without this second job that we think he has.
The judge takes full control, strips away the noise, and focuses strictly on the law and facts. You can feel it now. The talking is almost over, and a decision is coming.
Counsel, the issues currently before the court regarding temporary orders, not permanent ones. Mr. Hawley has set forth the child support worksheet, which I believe sets forth accurately a computation of the father's, the husband's income in calendar year 2024. I believe that is an accurate historical track record upon which to base his income. Further, the court also believes that his computation regarding Michelle's income is an accurate reflection of historical earnings for Michelle in the year 2024. So the court will adopt the domestic gross income numbers as submitted by Mr. Hawley. Further, this court is of the belief that it may be easier for these competing parties to deal with the children's direct expenses to have one parent pay them all. And I understand, Ms. Crispin, your argument that he has the superior income, therefore might be in a superior position to pay as they come due these expenses for the children. I note Mr. Hawley's claim that his client's been doing it anyway. But the court believes that at least temporarily, the mother should be tasked with paying the direct expenses of the children in accord with what his worksheet contemplates. But to do that, she's going to need the appropriate subsidy from the father for his fair share of those expenses. And I'll also note that child support is more than just direct expenses of the children. It's indirect expenses for these children, including the basic living expenses of that entire household. The court believes that an appropriate child support subsidy at this time is necessary, but in agreement with Ms. Crispin, I believe it may be premature or inappropriate for this court to enter temporary spousal maintenance orders. Therefore, the court will deny the request for temporary spousal maintenance. That may or may not be an issue should this case eventually be tried. The court need not decide that, but the court will adopt Mr. Hawley's computations as set forth in his proposed child support worksheet, with one exception, and it's a notable one. Mr. Hawley has a deduction for maintenance received and paid. That's going to have to be deleted, Mr. Hawley, but the court will not be making that order. This will have the net effect of increasing the child support amount payable by Trevor at the bottom of page 2 of the worksheet. That additional subsidy from father to mother, effective February 1 of 2025, will allow her, in this court's view, to pay the expenses of the children and maintain her household. Quite frankly, in looking at the disparity of incomes in preparation for this hearing, I don't know how Michelle's been doing it. She hasn't received any child support. She's been responsible for at least half of the shared expenses of the children. She hasn't received any spousal maintenance whatsoever, and yet she's been somehow getting by. I don't see exactly how. Maybe she's relied on savings, contributions from others, being extremely frugal. I don't know. Maybe all of the above. But the court at this time will order child support effective February 1 of 2025 in accord with the worksheet with the removal of the spousal maintenance portion as ordered by the court. Mr. Hawley, do you need further clarification on that? Okay, I take it that's a no from the shake of your head.
I always forget to unmute myself. No, Your Honor, you've laid it out just quite fine. Do you want me to draft an order for this?
Yes.
Or
Yes, and attach your, of course, updated worksheet. All right, Ms. Chrisman, do you need any further clarification of the court's current orders?
Judge, would my client be getting credit for covering the health and dental of 144 per month or no?
If that is, what did Mr. Hawley do with that in his worksheet?
I put 111. That's what I thought. That's what I got from the subpoenaed information, but I'm sure we can work that out. We're only $30 off.
Ms.
Okay, and I
Chrisman,
apologize. I thought it was 0. I apologize.
No, it was 111.
Okay.
are you satisfied with that figure?
Yes.
Okay, all right. Then no further adjustment will be necessary. I'm also going to take counsel up on his suggestion that we set a pretrial conference date. 30 days may be a little bit quick under these circumstances. I want to make sure that there's a complete exchange of information and an opportunity for some reasonable settlement negotiations and talks, and perhaps some written proposals going back and forth. So I think maybe a mid-March setting somewhere. That is an extremely busy time for this court due to trial settings, which are already established.
Does the court have anything the week of the 24th, or I'm not sure.
I apologize.
It's a jury trial all week.
Okay.
Yeah, and I'm out of town that week. What about that first week in April?
I mean, that's fine. That's fine with me if the court's available.
Check with my assistant. Mandy, I'm looking at the afternoon of Tuesday, April 1.
We only have something scheduled at 1:15.
Council, check your calendars for the remainder of that afternoon.
Yeah, I'm wide open.
Judge, would this be remote or in person for a pretrial?
It would be a Zoom proceeding.
Okay, other than about a 2 to 3 p.m. I'm available.
Okay. Let's just do this at 4:00 p.m. on Tuesday, April 1. It'll be a Zoom status conference and pretrial conference. I don't necessarily at this stage going to require pretrial questionnaires or an agreed pretrial order. I don't know if that's realistic at that stage, but I will want a complete update as to where settlement negotiations are and what issues remain, so that we can do appropriate further scheduling on April 1st.
Absolutely.
And I highly encourage the attendance of the parties as they have today. So Tuesday, April 1, 4:00 p.m. for further Zoom proceedings in the case. Look forward to receiving your order stemming from today, Mr. Hawley, with the new worksheet attached. Mr. Hawley, is there anything else we need to address currently?
No, Your Honor.
Mr. Hawley, would you go ahead and put the date and time for the next court proceeding in your order?
Yes.
All right. Ms. Chrisman, anything further at this juncture?
No, Judge, thank you.
Very well. If there's nothing further, the Sanders matter will be in recess at this time, and this meeting may be ended for all.
The ruling lands clean and firm. No spousal support, but child support is ordered and explained. This one hits both sides with reality. Like the video, subscribe to the channel, and we'll see you in the next one.